Minutes long. Panelists, I will private chat you 3 and 1 minute warnings, but I'm not in the habit of cutting speakers off. Okay, so before we begin, let me introduce our esteemed panelists. First up will be Professors Elizabeth Fisher and Sidney Shapiro. Professor Fisher is Professor of Environmental Law at University of Oxford, Corpus Christi College in the Faculty of Law. She researches in the areas of environmental law and administrative law, exploring the interrelationship between law, administration, and regulatory problems in different legal cultures. She has written a number of articles and casebooks in environmental and administrative law, and her 2007 book, Risk Regulation and Administrative Constitutionalism, won the SLS Peter Burks Prize for Outstanding Legal Scholarship in 2008. Professor Shapiro is Frank U. Fletcher, Chair in Administrative Law and Professor of Law at Wake Forest University School of Law. He's written 10 books, contributed chapters to 7 additional books, authored or co-authored over 55 articles, and is currently working on a book on administrative expertise. He's also the Vice President of the Center for Progressive Reform, a nonprofit research and educational organization of university-affiliated academics. After these two professors, the next speaker will be Professor Richard Pierce. Professor Pierce is the Lyle T. Alverson Professor of Law at the George Washington University Law School. Professor Pierce is the author of over 20 books and 130 articles on administrative law, government regulation, and the effects of various forms of government intervention on the performance of markets. His books and articles have been cited in hundreds of judicial opinions, including over a dozen opinions of the US Supreme Court. He's also a senior fellow of the Administrative Conference of the United States. The third presentation will be by Nicholas Bednar. Nicholas Bednar is a graduate student in American politics at the Vanderbilt University College of Arts and Sciences and a graduate of the University of Minnesota School of Law, where he won the Lockhart Award for exemplifying excellent scholarship, leadership, and service. He writes in the areas of bureaucracy, public administration, separation of powers, and administrative law, and has authored law review articles on these topics. And the final speaker will be Professor Dan Walters. Professor Walters is an assistant professor of law at Penn State Law and an affiliate faculty member in the Department of Political Science there. He's also an affiliate researcher in the Institutes of Energy and the Environment at the Pennsylvania State University. His current research focuses on empirically testing claims, undergirding proposed reforms to the regulatory state and administrative law, as well as examining political and legal approaches to promote a transition to a cleaner energy economy. His new article, Unrules, is forthcoming in the Stanford Law Review. And so before we begin, I just want the audience to know that if you have a question, please use the raise hand function in Zoom, and I will put you in the queue. And I'm sure there will be many after this terrific set of remarks. So Professors Fisher and Shapiro, please take it away.
Okay, thank you. I'm going to go first, and Liz is going to go follow up. We're very much pleased to be part of this wonderful group of commentators that the journal has assembled to talk about the future of Chevron deference. In October, Cambridge University Press published a book that Liz and I co-authored entitled Administrative Competence, Reimagining Administrative Law. The invitation to propose a paper for this symposium led us to consider the current debate over Chevron deference in light of our book. And we came to this conclusion. Some judges and commentators perceive overthrowing Chevron as a battle for American constitutional democracy, while for others, it just isn't. Our contribution argues what neither group recognizes is this: whether or not administrative law is to be the law of public administration is the root cause of disagreements about the future of Chevron deference. So I will take a few minutes to explain what we mean when we say administrative law should be the law of public administration. Until the 1960s, administrative law was concerned about two aspects of an agency's legal mandate: the legality of an agency's action and the agency's capacity to fulfill its statutory mandate. A long section of our book deals with the history of administrative law going back to the founding, and we see judges lawyers, and scholars debating how administrative law can both constitute an agency to accomplish its mission and ensure that the actions it takes are legally authorized. In fact, there's a discussion of how Marbury versus Madison fits this very pattern of concern about both legality and capacity. We argue that this dual concern is not only appropriate, but it is what makes administrative law the law of public administration. In the 1960s, however, administrative law stopped being the law of public administration when it became focused only on constraining agencies. The idea of also empowering agencies dropped out of sight. There are a number of reasons for this narrowing of administrative law, but the important point for this symposium is this. While the focus has shifted onto how to constrain agencies, the case law still reflects this older conception of administrative law as the law of public administration. For the opponents of Chevron, the capacity of agencies to implement their statutory mission does not figure into their thinking. For the defenders, there's also no discussion of capacity. Their deference is based on functional and pragmatic grounds. Moreover, unlike the opponents, the defenders do not resort to first principles. They do not offer an overarching or theoretical explanation of why Chevron matters, which creates this conundrum. Why does agency expertise matter? Why are agency interpretations legally relevant? Here's our answer. Agency interpretations are legally relevant because administrative law is about the capacity as well as the authority of public administration. It is the law of public administration. I'll turn our talk over to Liz, who will explain how Chevron reflects this older version of administrative law and why we believe it's important to defend the case using this insight. Liz?
Thank you very much. So what Sid has just described is really the dispute over Chevron, whether you support it or defend it or whether you argue that it should be abolished, is essentially a dispute over the nature of law. For those who want to overturn Chevron, the assumption is law is law is law. For those who want to defend Chevron, the argument is that actually agency administrative expertise is legally relevant to legal reasoning. Now, one could argue that the failure to see this is what Brian Taminar has argued, which is that there has been a failure for administrative law to really take the organisational nature of public administration seriously. Now, in one sense, he's right. And one could argue that the debate over Chevron is Exhibit A. One could also argue that the way we imagine Chevron is also another evidence of this. We think step one is the legal step. It's law. Step two, that's deference. That's agency administration. That's the kind of split. But in another sense, he's wrong. Well, in two different senses, he's wrong. First, as Sid has already highlighted, if we look historically, there is this rich discourse of administrative law as a law of public administration. Secondly, and more importantly, if we actually look at the legal doctrine, the legal reasoning in cases where Chevron is applied, what we are seeing is not only that administrative expertise is legally relevant, but it's legally relevant at all steps of Chevron. So just returning to Justice Stevens' test, the Chevron test, as he put it, it deals with the question of the court is reviewing an agency's construction of the statute which it administers. And the question is, how is that kind of conceptualized? If we look at step one, which is often seen as the legal step, this is really a step of congressional intent. And at that step, what we see in the legal reasoning is that part of that intent is expectations about agency capacity. Let me illustrate this with a short example. The case of EPA and EME Homer City Generation, a case involving the Good Neighbour state provision under the Clean Air Act. What we see there is that for Justice Scalia in dissent, is that he sees the statute clear on its face about what it means. The reason for that is he understands the expertise of the EPA as number crunching, as he describes it. If the assumption is that the agency expertise is number crunching, then actually the statute is clear on its face. For the majority, Justice Ginsburg, she sees agency expertise as far more about crafting a solution, and therefore the case is resolved at step 2. And obviously we can see assumptions about agency expertise relevant at step 2. Indeed, that's what happened in Chevron itself. But questions about the nature and the legal relevance about the nature of agency expertise is not only relevant at step 1 and step 2, it is also relevant at step 0. Here, let me cite Justice Souter from Mead. One of the reasons why Chevron is not held to apply is any suggestion that rulings intended to have the force of law are being churned out at a rate of 10,000 a year at an agency's 46 scattered offices is simply self-refuting. i.e., assumptions here about agency process, about agency capacity is driving legal reasoning. So overall, what we are arguing in our paper is the need for scholars to reimagine Chevron doctrine. And actually what's fabulous about the papers today is I think many of the papers that have been in this collection are doing exactly that. Now, reimagining might sound creative and radical, but that's not what we mean at all. Really, what we are arguing for is to think far more about the legal reality of Chevron as it is in the case law. As lawyers, we are always using our legal imagination. The separation of powers, the rule of law, these are mental constructs. Our argument is we want our mental constructs to accord more with legal reality. The late Ursula Le Guin drew a distinction between imagination and wishful thinking. Imagination starts from reality and returns to inform it. Wishful thinking is detached from reality. In arguing for a reimagining of administrative law, we are arguing for a connection with legal reality. Thank you very much.
Okay, wonderful. Next, we have Professor Pierce.
Thank you, Bijal, and I wanted to thank Christian and Duke for hosting us and me today. I'm always happy to visit Durham, though I don't really see as much of a difference today as I usually do when I fly down. Well, on to Chevron. So for 30 years, I was a very strong supporter of Chevron. I saw 3 major advantages to Chevron. First, increased political accountability for policy decisions. Second, less opportunity for judges to reflect their own personal preferences in their decisions, reviewing agency constructions of statutes, and increased national uniformity with respect to national statutes. Well, Chevron still has all of those 3 advantages. So it's really was quite reluctant to do what I did about 6 years ago and say, we can't afford Chevron anymore. Chevron produces horrible effects when it is combined with the kind of extreme political polarity that exists in the United States today. You look at any important public policy issue, and the Democrats are on one side and the Republicans are on the other. The differences are not subtle. They are massive differences of polar extremes. And what that does is produce flip-flops in policy every 4 to 8 years. Perhaps the best illustration of that is our policy with respect to regulation of the internet. So when a Democrat is in office, the answer is net neutrality, stringent regulation of the internet. And then whenever a Republican is in office, it is deregulation of the internet and elimination of net neutrality. And the courts have no choice, particularly when you combine Chevron with the follow-up opinions, but to uphold the agency. And that's what they've done. So we've had 3 flip-flops on that in the last 17 years. We're about to see a fourth. It's going to happen again in the next year or so. We could do fine, either under net neutrality or not net neutrality. One of the doctrines, one of the legal regimes encourages investment by ISPs and discourages investments by content providers. The other encourages investment by content providers and discourages investments by ISPs. And I'd be fine with either of those. I'm not even sure which one I prefer. The one thing we cannot tolerate is a legal regime in which the incentives for investment and the return on investment changes every time the identity of the President of the United States changes. That is a horrible, irresponsible way to govern. Now, imagine if the courts hadn't figured out, thank goodness, they figured out ways of avoiding the Chevron effect in some of the other really important contexts. But think about this kind of a world that we could easily have if you take Chevron seriously and apply it in every context. So the Affordable Care Act is the law whenever a Democrat is president and not whenever a Republican is president. DACA is the law whenever a Democrat is a president and not when a Republican is president. The Clean Power Plan is the law whenever a Democrat is the president. I mean, that not only makes a horrible mess of investment decision making and produces an environment in which we're likely to see no significant investment in any socially productive type in any of these contexts. It also produces a hellish environment for the individuals who are massively affected. How do you make decisions based to try and create an acceptable long-term future for yourself in any of those contexts or a dozen others without knowing what the legal baseline is? You got to know that in order to make sensible decisions. If instead what you know is, well, the law is going to change every 4 to 8 years, it's going to flip-flop the other way. I don't know how you live, and you're certainly not a pleasant life thinking about the likely consequences to you of the next election. I very reluctantly have concluded we have to return to Skidmore or something like Skidmore. So what's different about Skidmore than Chevron? Well, the Skidmore test explicitly values both continuity in policy and quality of agency reasoning. And that's really, really important. We need to place a value, courts need to place a value on temporal continuity of major regulatory policies and place a value on the quality of the reasoning used by an agency in support of whatever policy it prefers and any change in policy. Well, I'm really pleased when I look at Supreme Court, the pattern of Supreme Court opinions over the last couple of years. I've identified 6 that to me clearly reflect the increased tendency of the justices to reason in that way and not in the Chevron way. The best illustration of that is the Supreme Court's decision in the DACA case. So the court neither cited Chevron nor cited Skidmore, but it's very clear that the analysis that the court used as the basis for its decision was a Skidmore analysis and not a Chevron analysis. So what the court said was, well, agency, you're talking about making a major change in a policy, in a circumstance in which lots of people had expectations that the policy would continue to be as previously announced by the government. When you make such a major change in policy, you must provide good reasons, including data that supports your decision, and that shows that it is so important to make the change in policy that you want to make, that it justifies interrupting, interfering with the expectations of the millions of people who developed expectations based on the previously announced policy. I think that's where the court needs to go in the future, as long as we've got conditions of extreme political polarity. And I frankly don't see any of that stopping or reducing anytime soon. Well, I think that is would certainly be an improvement in terms of figuring out what agencies can and cannot do. But I don't think it's the long-term solution. The only long-term solution, the only way that we can return to conditions in which we have reasonable stability and continuity in the policymaking process, is to restore the ability to legislate. We lost that ability gradually over the last 30 years. So what we see increasingly in our field, administrative law, is agencies attempting to interpret statutes that are 30 to 80 years old, okay, and what they mean in the context of issues that Congress couldn't even have dreamed would have arisen back when they enacted the statutes, and where the statutes is absolutely nothing that is directly relevant to any of those policies. Well, in a prior time, 30 or more years ago, the answer would have been that the president sits down with the leaders of the House and the Senate and cuts a deal. And they sit down and say, okay, let's agree that we disagree. We're miles apart in terms of, now let's get serious about doing the people's business. And what that means is I got to give and you got to give. Then what would come out of that, not always, but on a lot of occasions, was a compromise that could be enacted by a bipartisan majority of both the House and the Senate. So how can we return to the time when that was a viable option? I think we've got to look very carefully at the mechanisms we use to choose candidates for office and to choose the leaders of the House and the Senate. I think we got to get rid of the party primary. It has horrible effects. They're low turnout elections that systematically favor activists with the most extreme views in the context of both the parties. And then they're used as a threat against anybody who has the temerity to consider compromising with the other side is immediately told, you can't do that. You're going to be primaried out of office. So we got to get rid of the party-based primary. And then the other thing I think we got to do is we got to change our system of choosing the leaders of the House and the Senate who determine what legislation, what bills are able to get to the floor for a vote. Right now, we have a system in which routinely the leader of the House or the leader of the Senate refuses to allow a floor vote on something that would be enacted by a majority were it to get to the floor. Well, I think the only way that we can stop that utterly undemocratic feature of our governance structure is to require that a supermajority to choose either the leader of the House and the leader of the Senate. So we don't have this horrible distortive effect that the current leadership produces, and that's certainly true of both parties and both houses. So with those modest suggestions, I'm going to sign off and let others grab the mic.
Thank you, Professor Pierce. So a few things. I am realizing that I don't have a handle on this technology fully. So I think I think we have a Q&A and we can raise hands. I see, and I can allow folks to talk. Okay, so yes, you can still, people who are interested in asking questions, don't hesitate to either raise your hand or to type it into, I guess, the Q&A. And if it's typed into the Q&A, I will read it for you. If you raise your hand, then I will allow you to talk once our panelists have finished speaking. As for our panelists, they've gone short so far. I don't think I've ever been in a position to say that before. So I'm going to stop timing people. The next two panelists, you have the advantage of taking the time you want, so I'm assuming it'll be approximately 12 minutes or so, but you have a couple of more minutes to play with if you'd like. And so our next speaker is Nicholas Bednar. Please take it away.
I realized I've been on mute. Are you able to see the PowerPoint that's on the screen? Okay, yeah. Great. Okay, well, with that, now that I've resolved my technological difficulties, I want to start by thanking Professors Hickman and Nielsen for prompting such a timely symposium. This has obviously attracted the attention of a lot of very prominent scholars, and I'm humbled to be in all of your presence. And I want to thank Duke Law Journal for inviting me to participate. The title of my presentation is Chevron and the Department of Justice, and it's going to be a bit more descriptive than normative, unlike the last two statements, though it clearly has normative implications. And so let's get started. So 2 years ago, I frequently sit and I read the DC Circuit opinions like so many administrative law nerds do. And I came across this passage in Guedes v. ATF. And they said, in this appeal, the government affirmatively disclaims any reliance on Chevron. And at oral argument, the government went so far as to indicate that while it believes the rule should be upheld at the best reading of the statute without any need for Chevron deference, if the rule's validity turns on the applicability of Chevron, it would prefer that the rule be set aside rather than upheld under Chevron. And this struck me as such an odd passage because I typically read court opinions, and so I typically don't have the insight of what Department of Justice is doing behind the scenes, except maybe in the case of the Supreme Court, where I'm more likely to read Solicitor General briefs. And it was odd to me that DOJ, while defending an agency, would say, either our interpretation is right or vacate our rule, because that completely neglects the second step of Chevron. And this is often cited as one of the most prominent cases in which DOJ has requested waiver. And this got me thinking more generally about how the Department of Justice thinks and uses Chevron doctrine during the course of representing agencies. And so there's a prominent line of literature that's infinitely long and what we mostly focus on when we talk about administrative law, and that's administrative law in the courts and how the courts are applying Chevron to adjudicate agency actions and whether they're choosing to defer to agencies under this standard of review. And this line of scholarship has talked about when courts should apply Chevron, how courts should apply its two steps, and the normative considerations of judicial deference to executive branch agencies. More recently, we have this second line of literature, which is talking about how deference has changed agency policymaking from within and how it has made agencies more willing to take broader interpretations of statutes than they might be willing to do under a more restricted regime. What's missing, or not as explored in the literature at least, is this idea that agencies' policies are often represented by the Department of Justice. And so they're reliant on the Department of Justice to translate their policies into things that courts will understand and apply Chevron to. So why should we care about any of this? The first is that the Department of Justice represents the majority of federal agencies in litigation by law. Only about 30 agencies have any amount of independent regulatory authority or any amount of independent litigation authority. And even then, we see those agencies using Department of Justice attorneys on their case briefs. The second is there's this debate in the literature about who is the Department of Justice's client. And there's been this like long discussion in both the political science and legal literatures about whether the DOJ serves as an advocate for the agency and should set aside its own policy considerations, or whether the DOJ is a tool of the presidential administration. And on the one hand, Department of Justice attorneys may behave according to professional norms, setting aside their political beliefs and defending the policies of their agency clients to the best of their abilities. Horowitz from 1977, long before Chevron was created, I guess not that long, but long enough, states, whatever their personal views on the legal merits of the way a given program is administered, most Justice Department lawyers continue to believe that most agencies, most of the time, are entitled to their day in court and to the best said in their behalf that the legal imagination can devise. So in the Horowitz line of thinking, Department of Justice attorneys set aside their own political beliefs and just kind of follow through with whatever the agency has. And under that sort of regime, we should see Chevron cited highly and effectively. Under an idea that the president controls DOJ and its centralized litigating authority, we're expected to see more reversals by political appointees in the department of lower attorneys litigating positions, and therefore possibly less Chevron deference in politically salient policies. Deputy Assistant Attorney General Jerry Jones once said a reversal by political appointees in the department may upset you. After all, you might have spent several days or even weeks developing a position, but it's something you live with and expect. And this idea that we would expect political appointees to reverse litigating positions in order to secure policy outcomes is what I'm talking about when I talk about this politicalization of Department of Justice litigation techniques. And so there are plenty of opportunities that this politicization of DOJ litigation could seep into the agency. The first is political appointees. The Department of Justice is a highly politicized agency, and the Attorney General controls the activities of the department. However, the Attorney General cannot oversee all of the activities of the lower level attorneys, and therefore it's unlikely that the Attorney General will be able to conduct enough oversight to see every case, particularly at lower district court and appellate court levels. The second is that the Department of Justice has an above average rate of departure during transitions, which creates a vacuum that needs to be filled. And Steve Tellis has this great article about the Reagan administration in which he demonstrates that what happens is the political appointees start hiring individuals who are closely ideologically aligned, and we see a transition within the department of how the department is arguing its legal cases. So my point here is if DOJ presses anti-deference positions, for example, Chevron waiver, Chevron may not have much of a future because if neither the courts nor DOJ are willing to acknowledge Chevron and its viability, I don't know who its defender remains other than scholars and private litigants. So the data I'm going to present, I'll go quickly through this, but is the pilot data of a larger, much larger dissertation-like project I'm working on. And the data set is merit briefs filed in the DC Circuit by the Department of Justice during the first terms of the Obama and Trump administrations. And to qualify for the study, they have to discuss the merits of a challenge to an agency action. They had to be accessible on Westlaw because I do not have funds to access PACER and are not appeals from a criminal trial or the denial of a FOIA request. So in the course of preparing this presentation, I read 1,000 briefs, 401 of those were eligible, and there are 433 briefs coded. I'm going to code for two things that I'll present here, which is whether the case cites Chevron and whether the agency argues for resolution at step 1 or step 2. There's a very large limitation here I need to highlight, which is I cannot easily observe settlements and voluntary dismissals, which could be the way that some of the more political litigation tactics come in, and probably is the way that they come in. So everything I'm saying is with that caveat. So the first thing I'll say is this is comparing the first term of Obama and the first term of Trump. And what we see is that Department of Justice has decreased its citations to Chevron by about 11%. So in Obama, that was 52% of citations, and Trump, it was 41%. That is a statistically significant difference and a difference in means. Almost all of those citations are in the standard of review section of the brief and the following section in which the agency discusses the permissibility of its interpretation. So they are not just throwaway citations, they are for the overwhelming majority, like actual invocations of Chevron. I'll throw this up here for fun, but just say like the trend for our in Kisser and Seminole Rock is both the same, but also greatly exaggerated. It's like a 19% difference there. So DOJ is relying on those doctrines even less than Chevron. And then for the uses of Chevron steps, something I thought was, well, even when DOJ invokes Chevron, it's quite possible that what's happening is the Department of Justice is recognizing that Chevron is the appropriate standard of review, but it's requesting that the court resolve the issue at step 1, basically adhering to a more statutory interpretation-based focus on Chevron rather than a reasonableness inquiry. And that's not what we see, at least not at the DC circuit. So the Obama administration invoked step 1, or argued that the court could resolve the case at step 1 more than the Trump administration. And the Trump administration argued that it could resolve Chevron at step 2 more than the Obama administration. However, the difference between these steps and across administrations is not statistically significant. And so based on both my reading of all of these briefs and the statistical analysis, I would say the Trump administration and Obama administrations were applying Chevron similarly in the Department of Justice in DC circuit cases. So a few brief other observations that I'll just note of things I tried and mostly failed. First, after reading Guedes, I expected to see more explicit statements of Chevron waiver. It's very rare. Guedes is the only DOJ case in the DC circuit in which the DOJ says we don't want Chevron deference. There are 2 additional cases in which the DOJ explicitly concedes Chevron doesn't apply, and like it clearly doesn't apply, but asks for Skidmore. And then there's another example, which is Global Telelink, where FCC attorneys retracted the Chevron arguments in a letter to the court, but the DOJ attorneys didn't sign on to that brief. Moreover, there might be this thought that the Trump administration was trying to constrict when Chevron applied, knowing that the writing was on the wall. We don't observe that. The Trump administration continued to push for Chevron deference for interpretations developed in non-rulemaking and non-formal adjudication actions. There are plenty of examples where informal policy statements were argued under Chevron standards and whatnot. There's insufficient evidence to show that ideology of the agency or policy contributed to DOJ's choice of Chevron or Chevron step. I cannot get any statistically significant result out of that, no matter which way I turn it. And I didn't see anything while reading it that suggested there was a pattern that political valence mattered. And moreover, when the agency intends to review or reverse the policy, DOJ often requests abeyance or voluntary remand. So Chevron is a very inefficient vehicle for policy change, and the DOJ is just better off asking for dismissal of the case if it knows the administration intends to overturn the policy. So in conclusion, during the Trump administration, DOJ invoked Chevron less often than during the Obama administration. However, aside from a few prominent cases, no significant difference in the way DOJ applied Chevron. And overall, at the lower level of appellate litigation, DOJ continues to apply Chevron in ways that benefits agencies and expands opportunities for deference in the future. Just a quick note on the future of the project. The plan is to collect all DOJ briefs defending agency actions from Reagan to present in all circuits, and apply text-based and machine learning methods to better identify patterns, because please don't make me read every DOJ brief from Reagan onward. Thank you.
Great, very interesting. Interesting that you took the time to track these patterns that we've all been intuiting, and very, very terrific contribution. Okay, so finally we have Professor Walters.
Great, thanks. And thanks to Christian and the rest of the Duke Law Journal editorial team for letting me be a part of this wonderful event. And congratulations on a great symposium issue. True to the title of this panel, I'm going to use my time to lay out a simple theory of the politics of Chevron's future. In fact, I'm going to go full politics and articulate a model that builds from the baseline legal realist assumption that deference doctrines we'll see in the future will be the ones that justices decide is the most likely to model to maximize realization of their policy preferences in the aggregate. This might strike some as crassly political, I'll admit, but what can I say? I'm half political scientist. So in my view, while there are 4 possible futures for Chevron deference, the model I construct tells us that we're most likely to see an evolution toward more Skidmore style deference on the court, rather than either a wholesale rejection of Chevron deference or an unqualified retention of it. And the reason for this is simple. Skidmore is a more attractive vehicle for the justices to maximize their policy preferences, given uncertainty about how the court's general policy preferences and the other branches' preferences will mesh over the foreseeable future. In other words, I think when we boil it down, harder rules of deference or de novo review make sense when the court can make a relatively strong prediction of future allyship or future opposition from a dominant lawmaking coalition. Arguably, the court could make such a prediction through most of the middle and late 20th century when Chevron deference was forged, since the political parties, while they had differences to be sure, were ultimately sort of cut from the same cloth. But the model I use says that when uncertainty about the macro political environment is high, Skidmore naturally prevails. Since we live in a time of high political competition and political uncertainty, or as Professor Pierce calls it in his great piece, political polarity, all bets should be on something that looks like Skidmore, although if that uncertainty changes, we could see a very different result. So what I want to do now is lay out some assumptions and building blocks for this model. My starting point is in thinking about Chevron as a tool in the court's interactions with the other branches. Chevron can be a drag when the court is persistently disagreeing with the actions coming out of the other branches, as it requires justices to expend effort explaining why a statute is unambiguous or that an agency's interpretation is unreasonable at step 2. But Chevron can also be a real time and effort saver when the court is persistently agreeing with actions coming out of the other branches, as it permits the justices to seize on ambiguities to rubber stamp the kinds of policies that they largely agree with, or at least that they don't care enough about to want to expend any effort engaging with it. All else equal, if the justices know that they're likely to run up against policies they don't like, they prefer not to have to bear the costs of explaining deference away. But if they know they're generally going to run into policies that they agree with, then they like deference because it makes their job a lot easier. So one dimension that we can use to model the politics of deference is whether or not the court expects the dominant lawmaking coalition for the foreseeable future to generally be in opposition or in tension with the court on important policy questions of the day, or if the court expects the dominant lawmaking coalition to be generally aligned with the court. And by dominant lawmaking coalition, I generally mean the center of gravity in Washington writ large. It's kind of a general sense of the politics of the time. At the same time, the justices won't always be entirely certain about any of these long-range predictions about which doctrine, deference or no deference, will be better given the configuration of the court's preferences vis-a-vis the elected branches. Particularly in times of deep political conflict, there may be no dominant lawmaking coalition. We might flip back and forth between very different worldviews and ideologies in Washington. So we need to add another dimension to the model that captures the uncertainty that the court has about whether the dominant lawmaking coalition will be an ally or an opponent for the court. So if we put, I'm just going to share something with you. Can you all see that 2x2? Okay, if we put these two dimensions that I've just been talking about together in a 2x2 table, we can make some reasonable predictions about how the court will likely proceed. The scenario where I think there is the greatest chance that the court will fully abandon deference is where the court has a high degree of certainty that the dominant lawmaking coalition will be opposed to the court's general policy outlook. In such a situation, the court is very unlikely to see any value in deference of any kind. Yet it's worth noting that this is also the least likely scenario because the dominant lawmaking coalition makes regular appointments to the Supreme Court. And the court's median is almost always relatively aligned with the dominant lawmaking coalition in a general sense. This is a central contribution of regime theories of Supreme Court decision-making. So far, so good. If we shift up the allyship axis to a situation where the court has a high degree of certainty that the dominant lawmaking coalition will share the court's preferences, we might expect that the court will retain or even strengthen deference to reap the benefits of deference more often without any risk that it will tie the court's hands. Now, things get more interesting when we add in the uncertainty dimension. Harder rules of deference or no deference start to look categorically less attractive if uncertainty is high. Instead, the court is going to value an approach that allows it the flexibility to alter its approach through micro adjustments as uncertainty is alleviated. You could think of this as almost a kind of Bayesian preference for Skidmore, given that it's inherently more amenable to real-time updating about expected payoffs from deference. The difference I would expect along the allyship opposition dimension in an environment of high uncertainty about that political situation would be pretty subtle. Given the uncertainty, a Skidmore of some kind is likely to be dominant, but perhaps when the scale slightly tilts toward expected allyship, the preference would be for a half-hearted embrace of Skidmore, maybe something more like what we saw in Kaiser versus Wilkie, where a more categorical rule of deference, our deference, was supplemented with some explicit conditions and prerequisites. But when the scale tilts toward expected opposition, but a highly uncertain environment, then perhaps something more like pure Skidmore would be expected to prevail as it allows the court to move more easily to de facto de novo review through applications of the Skidmore standard. In any event, while this is a simplified model, I think it could be powerfully predictive. Of course, a lot depends on how we define and measure allyship and opposition and certainty and uncertainty. And I have no doubt that these are debatable dimensions. But I think a reasonable case can be made that the current environment is one of fairly high uncertainty about allyship or opposition. In the next few years, it looks like opposition will probably prevail. We have a Democratic House and Senate and a Democratic president and a slightly right-leaning Supreme Court. But longer term, over the whole career of these current justices, the calculation is a lot harder to make. We live in a time of fairly high partisan competition, and it's not merely competition for the spoils of office. The parties have serious disagreements about policy. So in some sense, the model I've outlined here is like a different explanation of the same phenomenon that Professor Pierce identifies in his symposium piece. For Professor Pierce, political polarity makes Chevron unworkable, so courts will or should shift to Skidmore to make things workable again. Whether or not the justices are motivated to make doctrine workable, the model I've outlined here explains why they would do so out of self-interest. So we end up in the same place no matter what our underlying theory of what motivates behavior is. And that, I think, should be a pretty powerful suggestion that there's a lot more Skidmore on the horizon and a lot less Chevron. But of course, it could be that something significant changes on the uncertainty dimension. Perhaps the theories about an emerging Democratic majority, at least in the presidential election context, will put the right-leaning court in persistent opposition with the dominant lawmaking coalition, in which case we might even see Skidmore go by the wayside in favor of something closer to de novo review. But I just want to reiterate that this is never a very likely outcome. Going back to what I said earlier, the central contribution of the regime politics theory of judicial decision-making, going all the way back to Robert Dahl, is that the Supreme Court is almost never too far out of step with the dominant lawmaking coalition. Allyship is by far the more likely situation in the long run because of regular appointments to the courts. At any rate, this little thought exercise shows, I think, that the future of Chevron may be fairly predictable if we're able to get a handle on some very basic variables. One could probably complicate this model quite a bit, and there are undoubtedly some simplifications in what I'm saying. But at the end of the day, I think that thinking about how the justices are likely to see their long-term allyship with policymakers can really help us sort out which of several scenarios is most likely to be realized. This model is likely to be way off the mark if justices in the aggregate have very sincere and well-formed beliefs about the best doctrine that doesn't depend on how it allows justices to interact with the other branches. And I'd be happy to concede that that's a possibility. But I think if we're inclined to believe at all that the justices are policymakers and that they would prefer law that maximizes their long-term preferences, then this model is a helpful one in understanding what is likely to drive change in the doctrine in the future. So that's all I have. Thanks again for letting me participate on this panel. It's a wonderful event.
Wow, what a great set of remarks. Some trends across everybody's comments, including an emphasis on expertise, perhaps over concepts like political accountability. I have some of my own burning questions for everyone, but we do have a good number of questions and comments from a variety of sources. So please bear with me as I work through this. So I see a number of folks have typed into the Q&A, but I think given the length of the questions and comments, it might make more sense for you to articulate them yourself. So if you don't mind, I will allow people to speak. The first person is Joshua Sarnoff. If you wouldn't mind asking your question yourself.
Sure. Can you hear me?
Yes, absolutely.
Great. First, thanks to you all for terrific presentations. This is principally for Professor Shapiro and Fisher, but I'm happy to take comments from everyone else. And this is whether the real issue is less about the nature of the administrative expertise, but more about the bindingness of agency actions. So just the example was Meade-Souter example that you gave, and it's subject to challenge, not because low-level officials don't have expertise, even the relevant expertise, but because it's binding. And the same could be said for, void for vagueness and non-delegation concerns. And the rubber hits the road on the question of unreviewable agency discretion and prioritizations of agency actions, which are quintessentially administrative in the sense that you're saying. And yet we allow a review if they have binding effects and if there is sufficient legal standards to regulate the discretion. So I'm just wondering if you would say more about the core issue is not so much expertise as discretion and bindingness.
Do you want to go first?
Oh, go ahead, Liz.
Oh, okay. Thank you. It's a fantastic question. And the reason it's a fantastic question is it really gets to the heart of what Sid was talking about in terms of capacity. So as Sid has written in previous articles of his, and as we write about in the book, we tend to, as administrative lawyers, think expertise is expertise is expertise. It's administration. But what you're highlighting is, in your question, is in thinking about institutional capacity, that is, first of all, a multifaceted exercise. And there is also another question in the chat, sort of talking about comparative institutional advantage. It is thinking about the legal powers that is given to that body and how that interrelates with their, their information capacity, the other type of issues that, might affect an institution. So when we're talking about sort of capacity, we're not just talking about expertise. We're arguing a need to see that expertise as part of a complex institution which will have legal aspects. Does that make sense? And I will hand over to Sid as he...
Yeah, I would like to tell you that our plea to take institutional capacity into account will make administrative law a lot simpler and more straightforward. It won't. For the very reasons stated by the question. But it will make it more realistic, and it will pay attention to the importance of agencies' capacity to do what they're supposed to do under their statute. And we think when you reframe that, it does bring another perspective to questions like that posed by Joshua. And indeed, the challenge that Dick presented to us.
Thanks. I see Professor Merrill's hand. I don't know if it's a response to me or something else, but always love to hear from him.
Yes, I do see a bunch of hands. Professor Pierce, did you have something you wanted to say in response to the question?
Yeah, I just had one comment I wanted to make that was inspired by the excellent study that Nicholas Bednar presented to us. He posed the question, at least implicitly, what are we likely to see by way of government lawyers disavowing Chevron deference in the future? And my prediction is it's going to end now. I think it was a phenomenon that was largely unique to the Trump administration, and it fits with many other patterns of lawyering that took place during the Trump administration. The reason I predict that as long as Chevron exists, government lawyers are routinely going to cite Chevron and make arguments based on Chevron, particularly in the lower court, as the Walker and Barnett study showed. And there's a simple reason for that. That's how you win cases. And what we teach lawyers to do in law school is your job is to win cases. And in the vast majority of circumstances, the government and the agency are on the same wavelength. So the job of the lawyer is simple. Defend the government and win the case. If you disavow Chevron, you maximize your chances of losing. Just as if you don't use notice and comment, you don't engage in reasoning, you don't anchor your decision in all of those respects, you will lose. And this fits perfectly with the remarkable 10% success rate that the Trump administration experienced in trying to defend its decisions in this area as compared with the 70% success rate of every prior administration. I don't think we're going to see future lawyers in either Democratic or Republican administrations replicating the patterns of behavior that produced utter failure for the Trump administration.
Yes, I actually had a similar question myself about the likelihood of this continuing, and I think Professor Pierce has a very strong view on whether that is to be the case. So another question or comment was from Ronald Krotozinski, but I don't see him on the attendance list anymore. So there's a long question here to be read.
He is, Bijal. He's on my screen.
Oh, he is. Okay. Well, let me see if I can go ahead and find him.
Hi, I'm actually here.
Terrific.
I just was working as a panelist. That's how they had me log in
Got it. Okay.
The question really is this, and that is, I'm totally on board with, I think, what all the panelists, going back to Judge Sutton, have said, that pixie dust and magical implied delegations without regard to the quality of process or the nature of the question, and the question being better answered with expertise, technical expertise. It sounds like we're all on board on that. I do think, though, there might still be a separation of powers kernel that a court has to address, and that's whether an agency has the power to speak with the force and effect of the law. The EEOC doesn't, for example. It can't conduct notice and comment rulemakings, and it doesn't have the power to conduct adjudications. And so I think technically there is still a kernel of separation of powers that a court should have to address itself to, but it may be like Aquinas with angels dancing on heads of pins, because I suspect a court, even if it were making the decision, because an agency lacks the power to speak with the force and effect of law, would still apply Skidmore. I was just wondering if the panelists think that there is a smaller separation of powers question that a court would have to address regarding the technical delegation of power to speak with the force and effect of law, if in fact it's the agency and not the court. It's kind of a Scalia point in Brand X. And maybe it's irrelevant, but and it is a formalist question, I guess, but I was curious what the panelists thought. Is there really no separation of powers issue involved in deciding whether a court should defer or make the decision itself as a technical matter?
Well, let me start. Thanks, Ron. I think what fuels our argument is a little wider notion of legitimacy. That the legitimacy of agencies not only depends on their authority to act, but on whether they fulfill what, after all, is a democratic command to protect the public or provide some benefit. And we may disagree with those statutes. They're way out of date, as Dick proposes. But the fact is they remain on the books, and the expectation, the legal expectation, is that agencies are supposed to do something with them. And so it's not purely a separation of powers question for us. It's both. It's legality and capacity to act, because legitimacy is very much tied to the agency's ability to deliver.
Can I just, following on from that, and at the end of your written comment, you write, technically, however, it's the court's call. And to me, this is the starting point. I mean, what we're talking about in the Chevron test is really the law, whether it's deference or not. And clearly, constitutional principles, whether they be the rule of law, non-delegation, separation of powers, are relevant in that legal reasoning. But I think the question is, how are they relevant? And this comes back to the beginning of my comments. I mean, what is it that we are thinking is law? Sorry, it's a very existential question to put on the table. But what is this legal reasoning, and where does the source of the legal reasoning come from?
Do you accept the policy versus law, Professor Fisher? Do you accept the policy versus law dichotomy, or do you find that bogus? I'm just curious, because that's how Chevron has been.
Yeah, no, it's good. And I should say, as you can probably figure out from my accent, I'm not from the US. And I should say, I'm studying this as an outsider, and let me put that on the table. I find that often our use as administrative lawyers of the word policy is a shifting label we put on many different things that we don't quite know what they are, but we don't think they're law. And that sometimes gets in the way of more rigorous legal analysis. And I would say that doesn't only happen in the US, that happens in the UK, that happens in Australia. It's not really answering your question.
It's why I suggested that we focus on bindingness.
Yeah.
I have a somewhat different response. I think this is the separation of powers issue here is really based on a characterization problem, and Ron just referred to it. To me, the court had it right in Chevron, where basically what it's saying is the process of statutory interpretation produces a legal conclusion that Congress did not address the issue. the statute is ambiguous and Congress did not address the issue, well, then the issue is by definition an issue of policy. It's certainly true there are occasions when Congress doesn't address an issue and enacts an extraordinarily vague and ambiguous statute. I teach antitrust law, so I'm familiar with two that are the most vague and ambiguous statutes in all of history. And in that context, courts don't have any choice but to make the policy decisions because there's no agency that has been given any power to do that. And so Congress, rightly or wrongly, has said, you judges figure out what the rules of the game are. But where Congress has identified an agency to which it has delegated policy-making power, I don't have any question that once you conclude that the statute is ambiguous, you have addressed the issue of law definitively, and then everything else is an issue of policy, and then we're into how should courts review agency resolutions of policy issues.
The formalist versus functionalist debate regarding whether Chevron complies with the separation of powers has kept scholars busy for quite some time, and so remains relevant here. And so we have a couple of more questions in terms of the participant list. Steve Solander has been waiting for some time, so if you'd like to ask your question.
Yeah, my name's Steve Sealander, and I am an attorney in the Detroit area and a member of the Administrative Law and Public Policy section. This is a bit of an aside question to Professor Pierce. I agree 100% that the legislature hasn't been doing the job for a long time, and that the political polarity is the problem, and that the primaries are the major cause of political polarity. We in Michigan have just passed a law, a constitutional amendment to change the way districts are gerrymandered and hopefully get away from that. And that was a hope that I had to help move away from political polarity. But I think you're correct that the way to get away from it is to get rid of the primaries. But I'm wondering if that isn't totally wishful thinking.
Probably. I have to say that I'm actually desperate at this point. I think we are dealing with a phenomenon that is a serious threat to the continued viability of at least our form of democracy. You know, the framers intentionally made it difficult to enact legislation, much more so than in most any other democracy. But the framers, I don't think, anticipated the extraordinary level of political polarity that now exists. When you couple those, we have, I think this really threatens the future viability of the entire enterprise that we embarked on in 1789. So I'm desperate for solutions. And I'm not saying that I think there's a good chance of getting this implemented. And if somebody else can come up with another idea that has a better chance of being implemented and some chance of moving us in the right direction, boy, I'll jump on board in a second. I can only say that while I think it's unlikely that Congress state legislatures in this case, will take this action, I pray they do, because I do not see a good future for the United States unless they take some actions to address the situation we now have.
Next, Professor Merrill, I think, has a question. So I'm asking you to unmute at your pleasure.
Great. This is just a comment, I guess, on Nicholas Bednar's interesting empirical work. So I have been curious, try to figure out why the Supreme Court has declared a moratorium on Chevron. It hasn't really relied on the two-step formula since 2016. And one thought I had was that maybe it related to the briefs that the Justice Department, the Solicitor General, was filing in the Supreme Court. So I take it that Nicholas has not looked at the Supreme Court, he's looked at the DC Circuit, but I do have a research assistant, a very good one, who's an articles editor on the Columbia Law Review. And I asked her to look at the briefs for the first 4 years of the Obama administration, the first 4 years of the Trump administration, or the only 4 years of the Trump administration, to see just basically how frequently Chevron was cited per brief, or per brief that involves an administrative law question. And the answer is there's no statistically significant difference. So that's interesting. I think in the DC Circuit, part of the explanation for what he finds is that the briefs are largely written by lawyers in the litigating divisions of the Justice Department, the Civil Division primarily, but also some of the other divisions. And they are kind of weakly controlled by political overseers. So they may just sort of perpetuate the standard lawyerly assumptions that the Chevron doctrine is the right standard of review. In the Supreme Court, it's a little harder to understand, and there are some anecdotal instances of the case of County of Maui versus Hawaii Wildlife Federation last term is one where the EPA had come up with a very, I thought, reasonable interpretation of the Clean Water Act, and the Justice Department, the Solicitor General, did not ask for deference under either Chevron or Skidmore for that interpretation. So there's some anecdotal evidence that the Justice Department was disclaiming or not invoking Chevron, but apparently the raw numbers don't suggest that that's what's happened. I do think the Trump administration is a very odd object to study as a political science matter in this regard, because the high levels of the lawyers in the administration who were ideologically opposed to Chevron witnessed the fact that they carefully vetted their first two Supreme Court appointees, Gorsuch and Kavanaugh. Both, not coincidentally, had publicly criticized the Chevron doctrine, whereas the Trump administration itself was so disorganized that they've probably never got around to really controlling the administrative apparatus in such a way that they would have had a strong institutional interest in invoking deference. So it's kind of an odd doc to study as a matter of political science theory. But anyway, I was interested in Nicholas's conclusions about the DC Circuit because I think they somewhat parallel what happened in the Supreme Court.
And if I could just if I could add to that, I find a statistically significant difference, but if you read the briefs, I don't think it's actually all that meaningful from a yeah, I can pull a statistic that tells me there's a significant difference, but it's just 12% and they're still citing Chevron 40%. So I agree with you that it parallels kind of what we saw at the Supreme Court. I didn't do the statistical analysis on the Supreme Court that you did, and so it's insightful to hear that we're seeing similar trends there. But it kind of suggests that either the Trump administration didn't get a hold of DOJ in the way that it might have wanted to, or DOJ sees it to its advantage to keep Chevron moving in the direction it has been for the last 30 years. So.
Okay, I think we have time for just one more question. And we have a question in the Q&A from Mark Prada, which I think might be a useful question for Dan Walters, to maybe apply his framework and tell us if he thinks this would have come out differently in this instance. So Mark asks, do you think that Kaiser might have been decided differently, possibly along the Gorsuch position had Barrett been on the court then? So do the ideological preferences perhaps of this justice, would they have changed maybe the outcome in this case?
Great, thanks for the question, Mark. I suppose being consistent with my presentation, I'd have to say that it kind of depends on what Justice Barrett's sort of prognostication is about what the dominant lawmaking coalition over her 30 or 40 years on the court is going to be, and how allied it's going to be with her position. So, I think a lot of political scientists have a more crude attitudinalist kind of take on things, that it's really just a short-term calculation, and we can estimate the ideology of a justice. And I think people, probably approaching it from that perspective, probably having Justice Barrett on the court instead of Justice Ginsburg would have made a difference in that case. But I really think that the justices are thinking more long-term about deference. They're not thinking in terms of what's going to help me in this case or in the next year. They are really thinking about their entire careers and their legacy on the courts, and so that makes it very difficult, I think, for me to sort of offer a prediction about what would have happened had Barrett been on the court. I think that depends on her evaluation of the political environment.
Okay, so on that note, I want to thank the Duke Law Journal and our esteemed panelists and terrific audience for a wonderful hour and 15 minutes, and I look forward to the rest of the conference. So thank you very much, speakers.